considerations. And I think that's the danger.
So another one concerning Alexis' perspective on balancing. I wouldn't say that he completely equated, as I understood you, balance with subsumption. He wrote that the formula of the weight.
Right. It's analogous. Weight formula and subsumption.
No. I think that balancing is a precondition for subsumption because you had to find the upper premise. So it's cannot be analogous. But he wanted to say that it has kind of the same rational value. That it is in the same sense it is rational as subsumption. Because Habermas attacked him on this point that it's kind of irrational.
Yeah, and I think, well, of course, Alexis' theory is pretty complex, and we could discuss it here because there are different things he talks about in different places. And this is taken from this article on balancing and subsumption, where he says that the sumption formula represents a scheme which works according to the rules of logic. The weight formula represents a scheme which works according to the rules of arithmetic. The weight formula directly or analogously, the sumption formula connects them directly through the rules of logic, the weight formula indirectly or analogously by interpreting the judgments through numbers. So
it's something different.
Well, yes, they are different, and that's my point. That I don't think weight formula.
The common denominator is only some practical rationality. Whereas,
but I agree.
In case of assumption, is even formal rationality.
Right.
Not practical.
But I think I tend to agree with Habermas there. The rationality, because Alexei wants to defend the thesis.
But then you criticize instrumental rationality.
Well, what do you mean by instrumental rationality?
Yeah, at the end, like that relativizing, some. At the end, you were referring to Tamanaha, that seeing balancing as a form of instrumental rationality. There would be like, I don't know, relativizing values, virtues, values, rights, in this aspect.
Right, and I think that's a logical conclusion.
But balancing is
when you think
the opposite.
Well, okay, I think
maybe later.
We should talk about balancing later. Because it is a complex question, especially as an interpretive question of Alexei. Julian Rivers was my examiner for DPhil. He's the translator of Alexei's. So we did have pretty sophisticated discussion about that.
All right, Filippo. Yeah, just I'm not sure you will have a lot of the discussion, but your example reminded me of an ECHR case that I looked into because it struck me as the perfect example of this. I don't know if you remember when in 2002 there were people held hostage in a theater in Moscow, and then the Russian special forces intervened, and out of about 800 people, 80-something were killed, and the case was brought to Strasbourg. And I was curious to see the reasoning of the court, because obviously the relatives of the victims were challenging the operation, the rescue operation in itself, and also the following criminal investigation. So to me, it sounded exactly like the perfect case of instrumental assessment of human rights against another human rights. In this case, it was really like X lives against 800 lives. So basically, I think that the court didn't want to go into this and simply stated that the choice of the means for the rescue operation were within the marginal appreciation of the state, subject to certain minimum condition of reasonability and reasonableness, and that, in fact, the fact that they would have, and I think it was more foresight, considered the possibility that someone would die in the operation was okay. So it seems to me that the result was one of these two dilemmas, but they tried to ride the foresight side effects thing. So in this sense, I don't know if it's postmodern or not, but it seems to me that they didn't expressly subscribe to the opportunity.
No, thank you. That's great. And I completely agree that there are cases like that, that you can find cases like that. In fact, this whole idea of proportionality, I think, was the inspiration. The ethical proportionality was the inspiration for legal proportionality. And when you look at the first mentioning of proportionality in Strasbourg in 60s, the Belgian linguistic case, it was mentioned as a proportionality between means and ends. And it took 20 years before proportionality became synonymous with balancing. So at least at the beginning, and I think there still are traits of this proportionality in Strasbourg. But I think there's more and more balancing proportionality present. And when you think of the Pretty case, Mrs. Pretty complained that UK blanket prohibition of assisted suicide violated her right to respect her private life and my other rights. And the court, she lost the case, but in the reasoning, the court basically created a right to assisted suicide, but said it was outweighed in the given circumstances. Which to me is another example of this understanding of rights as principles of optimization and of balancing. There's a right to assisted suicide, it's just balanced in this case, but in the future case, maybe it will not, it will be balanced the other way. Whereas if you understand rights as rules, and there is a rule, and if the right to respect for private life does not include a rule that you have a liberty to be assisted in suicide, then it's end of question. There's no further discussion. There is no right to assisted suicide. And will not change in the future case because there's nothing to balance. But, so I guess I just want to say thank you for the example.
If I may. Okay, I will be the last to pose the question. Good.
Since I'm not an expert in this field, forgive me if you already said it, but I actually missed the point where you call it postmodern.
Yeah, good. Thank you. The only reason why I call it postmodern is that this conference had an cycle. I never called it postmodern before, but I figured, I understood postmodern here only as everything that has happened in the last 20 or 30 years. Very broad definition of postmodern, I admit. Sorry for that. But in my thesis, I just call it proportionality as balancing.
Could you say something more about how the proportionality works in the Charlie example? So when you're using this golden rule and
right.
using things, what is it?
Thank you. Well, I think, so you're not intending to kill the 5, but you foresee the side effect of the death of this one person. So you're now facing the decision, shall I turn the switch or not? Is this an acceptable side effect or not? I think the first question is, if I were the golden rule, if I was in a position of this one person, would I have agreed to that? Is it fair? Am I being fair to this person that I'm causing harm to? Another, do I have a special role or commitment that determines what I should do? If this one person was my child or my wife, that I do have a special commitment to. Or if it was a person, that I'm a bodyguard, and this is the man that pays me for protecting him. I think the situation changes, and the acceptability of side effect changes. Whatever I do, it will be potentially a good action with bad side effects. One side effect is 5 dead people, the other, in the other alternative, 1 dead person. So if all I know about this case is this, I think it is reasonable and good to choose the death of 1 rather than the death of 5, because the death of 5 people is worse than the death of 1 person.
But isn't that always so, irrespective of who that person is and how committed you are to her or to him?
Well, but once you bring in the roles and commitments, once you know the people, it gets more complicated. You get more considerations that are incommensurable, I think.
Right.
So, in some sense, there are no, and I think this is important to realize, there are no clear or bright rules when you're considering judging the side effects. I mean, there are some rational guidelines, such as golden rule, blah, 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 but it's not clear-cut. It's not, you apply it and get a result. It does require a virtuous person, a person who has lived his life well for many years, has much experience, virtuous old man or old woman. They are experts in evaluating side effects. No one else, really, I think.
Yeah.
But isn't it true that in the case of European human rights, there are only 3 exceptions to the right to life? Self-defense, suppression of rights, and police action. So in this case, one could say that right to life is absolute. So you don't have the right to decide between those 2 choices. I mean, similar case was probably familiar the case Giefgen versus Germany, where a small girl went missing, and Frankfurt police captured one suspect, and they got some indication that he knows where the missing girl is, and then they used violence, torture to get the evidence from him. And after that, Mr. Giefgen complained to the court saying that Germany violated the prohibition of torture, and the court said yes, you violated and you have to prosecute those two policemen who tortured them. So what I'm saying is, isn't your case like, it's impossible, I mean, from the legal point of view, it's impossible. We don't have the right to choose between the two lesser errors. You know?
Well, didn't you just give me an example where they followed
But still, it was condemned at the end, you know? They shouldn't have tortured.
But I agree they shouldn't have tortured. Yes, that's my. I mean, torture. I think right to life or right not to be tortured includes your right not to be intentionally tortured, held against everyone. It's an absolute rule. I don't think there's any balancing. And what you mentioned about the Article 2 of the European Convention, I think it's more precise to say that those are not exceptions to the right to life, but they're specifications of the right to life. And all those three cases are examples of when you're caused to die as a side effect of police actions that are trying to stop you, or you know, self-defensive action is a nice example of unintentional killing. If an attacker attacks you, and the only way to stop the attack is, you know, shooting his head, you don't intend his death. You're causing his death as a side effect of your self-defensive action. So I think it's a specification of the right to life, and every right has to be specified into 3 rights.
If I may, or did you want to say something?
But I think, I mean, I don't know, but it's 11:40.
Just one last question, if I may.
You're the boss.
I mean, you're probably familiar with the case of the U.S. Supreme Court.
Somewhat.
They would much more follow your idea, and I'm really sympathetic to this, the idea of the rights as rules, right?
Right.
They do not engage in this kind of a notorious balancing as our courts do, right?
Right.
Whereas, and this kind of balancing, even those who support it, they would need to admit that this kind of balancing lacks predictability, it affects legal certainty, you're not sure which rights you actually have, whether you have the right in the first place. But anyhow, then my question would still be, and here I would side a bit with Marco, how do you determine the content of a right, so to produce a rule?
Yeah, yeah.
Right?
Well, I think that's...
Or maybe, what would you...
No, that's a very good question, and I think it raises the whole idea of the institutional arrangement. Why do we need a Strasbourg Court at all? And if we do have it, is it a good idea to have just a list of rights that are not specified? Because clearly the European Convention rights are not very much specified. So once you do that, you have a list of unspecified rights, you create a court, you're sort of creating a space for formulating new rules and new rights. Right? So yeah, the courts are specifying the rights, but legislators could be specifying the rights. I mean, I'm kind of neutral in this presentation, but I think it raises the institutional question of the importance or the need for European Court of Human Rights.
Anybody else?
Yeah, maybe just a short one. So what you're implying is basically the means used or applied should be legal, otherwise there's no balance.
Right. Yeah. Thank you. Okay, thank you very much.
Okay, thank you very much.
If anyone's interested in the paper, I can send it to luterancollegium.org.
I'm not sure.
Just send it to me and we'll just send it to all the participants, I guess. And now we move to the student panel. And Jan is going to chair it and tell us all the details.
Alright, so we start with the student panel and we have 3 presentations. First by Petja Mihalic.
Yeah, that's me.
Yeah. From European School of Law.
I should sit there.
Yeah, that's good.
But I think you should stress the time limit.
Yeah, and you have 10 minutes for presentation and 5 for questions.
I'll just start with objectivity and law.
Roman goddess of justice, Justitia, whose statues we often see at courthouses and courtrooms, personifies moral force of judicial system. Justice is so an integral part of judiciary that it must be shown outside, as if saying, here not only law but justice rules. People need to know that moral standards by which they live are the same moral standards that will judge them if they ever come to court. If standards of justice written in legislation, in penal codes and law books are different in serious matters from what the people perceive as just, trust in the legal system will start to fail. Thus, paramount necessity for a legal system to be just in order to be trustworthy and efficient. Attributes of personified justice representing such legitimate legal system are also scales in her right hand, symbolizing objective standard of arguments for and against in a case, double-edged sword in her left hand, symbolizing the court's power of reason and coercion, and finally, she is also blindfolded. A blindfold symbolizing that one will be judged objectively, regardless of one's gender, wealth, or any other bias. Notice the stress on objectivity of the law. Law's nature alone demands objectivity. It is abstract, unbiased, formal, and systematic. Although it is a fact that legal interpretation is always to some extent liable to interpreters' subjective perception, it is not a fact that objective law per se doesn't exist. In fact, we want to prove that it does exist, that everyone should acknowledge it, and that finally everyone will acknowledge it due to its power of coercion. Law in itself and people living by it would be much better off if law could somehow break free from theories that belittle it by making its core nature relative, thus unstable, or trying to subdue it to someone's subjective will. Such distortions and violations of the law using natural law premises cannot go unpunished. Okay, let's ask ourselves why so much state coercive apparatus is needed for laws to be upheld. The answer is because we are living in a positivist environment where morals are severed from the law. Morality being a subjective matter and positive law being objective matter. If morality is subjective, that is relative to individual and positive law understands itself as objective, then no wonder law is often seen as alien force trying to curtail individual moral view, which on its own right is seen by that individual as objective one. Law, thus stripped of its inherent objectivity, becomes a mere question of coercion, and even fundamental liberties and rights of men can be changed if such is the intent of the current clique in political power. That is, individual subjective law is legislated and thus endowed with objectivity. The verb change was used instead of the verb violate to indicate a sense of arbitrariness which it implies. Arbitrary changes make our attitudes toward the outside world highly cynical. State laws begin to look to us as something artificial, so we try to live by our own moral laws, which are often different from positive legislation, and certainly different from those of our neighbor, even concerning fundamental principles of natural law. Laws are reduced to a state of pure material at our disposal to be used and abused for pragmatic purposes, which being objectively morally wrong are at the same time objectively positively lawful. If state officials whom people should look up becomes utilitarian and pragmatic, why anyone else should be any better? So positive and natural laws are being violated. The one who has power gets away with it. The one who does not is punished. The most obvious expression of such a power is plutocracy, cronyism, and nepotism. In short, corruption. Okay, where does this pragmatic stance come from? It comes from the absence of absolute law or universal fundamental norm of law. For Fichte, one of the three German idealists, others being Fichte, Schelling, and Hegel, absolute fundament of all reality is spiritual. Okay, I don't think I have time to go into these details, but let's say this is too much. So, we come to a question why there must be a universal fundamental norm in which positive legislation must be rooted in order to gain objectivity and legitimacy. Constitution of the Republic of Slovenia states in second article that Slovenia is governed by the rule of law, and in 14 articles ensures equality before the law. These two postulates invoke objectivity through independent government of law over the people and equal respect of dignity for all governed by the law. Both values hence strive for objectivity, which is a form of justice. Law, in order to be legitimate, must be just, and this in itself is a question of objectivity. Principle of constitutionality and legality, which is closely related to legal formalism, demands that laws are in conformity with the Constitution and generally accepted principles of international law and with valid treaties ratified by the National Assembly. So they must also be published prior to coming into force, and they must not be retroactive or ex post facto effect. Legitimacy, on the other hand, is being defined by its level of righteousness or justice. But how can we tell justice from injustice, right from wrong? Can there be a criminal offense called malum in se, an intrinsically evil act, as the translation goes, as opposed to malum prohibitum, which is wrong or unlawful only because prohibited by state? In first case, it's an act. In first case, act is absolutely wrong, and we can't change it. Whilst in the latter case, state is acting as cooperator of natural law, endowed with power of discretion. So why is that we know that something is in one law is unjust, or that one conduct is malum in se? In European continental law, there is legal principle nullum crimen nulla poena sine legea previa, which prohibits ex post facto laws. There is no malum prohibitum if there is no law that would ex ante facto prohibit it. Using argument by analogy, we argue that there is no conduct malum in se if there is no natural law that would define it beforehand as such. Lastly, we state that argument a completudine not only holds in positive legal system, but holds just as well in natural law system. So, and we will elaborate this further. Okay, I think I will, because I have too much. Maybe just the relationship between time and eternity. This is paramount. If there is natural law that is eternal, it is in our best interest to legislate it in our temporal positive legislature, because positive law that sanctions our illegal conduct in time, but natural law sanctions for eternity. Where positive law doesn't sanction what natural law defines as malum in se conduct, people are misled into thinking that such a conduct is right when it really isn't. At this point, we must reiterate that the state is not creator of natural law, or does it sanction its violation if not legislate it. Obviously, law without coercion apparatus that could sanction its violation wouldn't really be a law, because no one would take it seriously. Natural law exists in time, but sanctions often follow to eternity. It is thus important to sanction transgressions of natural law with temporal penalty, because by definition it is milder. Life sentence in prison amounts to a couple of decades in prison, but life sentence for eternity is eternal. What we do in life echoes in eternity. Heaven or hell, we decided today. Thank you.
Any questions for Peter?
I think the thing I stated here, I like common sense. So
That's very good. So you just any question, you would just come across as super stupid.
Marco has a question.
Okay, if I have to have a question, then I would ask you, so, but then how far can you go with it? Because we saw right at the beginning that the more you go into details, the more you get into troubles. And,
no, the more you get into order.
Yeah,
I don't agree with this. I mean, yeah, there's always mystery, that is for sure.
Yeah, but on what basis is the order established? Yeah.
In details, we find order. If there wouldn't be order, then science wouldn't research things. Science is researching and finding order in things. Things are regulated.
But how can you justify it? By what? But your intuition?
No, by science. Intuition, of course. Intuition is order written in our core, in our being, in our heart. Of course, with intuition, but also by science. Science exists, but natural law and intuition also exist.
Thank you, Maria.
Hi, thanks for your paper. I wanted to ask in relation to the last part where you were saying about temporal punishment and eternal punishment.
Yeah.
To what extent? Well, first, do you think law can make people good? So this is a question that requires self-awareness. And to what extent
What
do you
if law can what?
make people good? Can law make people good?
Oh, absolutely good? No, of course not. Just they're.
To what extent
if,
then?
Natural law should be placed in positive law to extend just for the aim that people would not be misled that something is good, whereas it's not. Because if they think that something is good, but in fact it is not, punishment, natural law punishment will follow. That's for sure. I don't have any thoughts about it.
You better believe it.
Yeah. In fact, anyone will see for themselves.
I have a question. It's probably off the mark, but I would be curious to know, to ask you if you could develop on this universal natural fundamental law. It suggests to me that it's not depending on any territory or country. So you develop on the time character of this, so it doesn't change necessarily with time, although its implementation and its codification and its positivization, I don't know, it actually depends and it can change over time. What about the territory? Is that one universal norm that is the same or it's declined differently over space? I will try to give you an example, and you might even say it's not relevant at all. But human dignity, we try to investigate its quality, that is untouchable, it's unconditional, and yet we realize that although in everywhere we conceive human dignity as universal, in fact the conception that we have of human dignity might change from place to place. It doesn't mean that we consider differently whether it's universal or not. We agree that it's that, but it's just different the way we conceive it from place to place. So is that something that might further your inquiry into the universal norm, or you're not interested in the application of it?
Sure. Yeah, I am very much interested in application. I just didn't have time for application.
Okay.
Yeah, I mean, human dignity is a universal norm, and it's not. Its application is not that different. You can find this definition of human dignity in Universal Declaration of Human Rights. So this is for all the humanity. Or it states for all human family even. So I would not agree that it's very much different in Japan as it is here.
Okay, but maybe in Japan they would think that it's absolutely against human dignity not to be apologized when you, well, it's a little bit stretched, but if you're being harmed and you're not apologized, that's incredibly against your human dignity, whereas probably in Western society they say we don't care as long as you pay damages. I don't know, I'm just saying that we all agree it's universal, or we might have different vision of human dignity.
I would say that this is more a part that pertains mala prohibita part of human dignity, not mala se.
Okay.
Even human dignity, I think, can be severed in two parts: mala prohibita and mala se.
Okay.
All right, thank you very much. Now we have Mario Krišić from University of Zagreb.
The topic of my paper is the principle of omnis iudex in res sua and problems that mainly for some, at least for some theorists can be with this principle. The principle omnis iudex in res sua expresses the freedom of state to interpret for itself what the law is. State cannot be compelled against its will to submit its disputes with other states for international